Our 30th class has more of a law class vibe than a history class vibe, and we're going to be focusing on what I consider the most important legal precedent in U.S. history, Marbury versus Madison. And that's not a very unusual opinion, by the way. But before we get into Marbury, I want to look at some past legal milestones for context and continuity over time. Hey, those are AP skills, and I understand this is a U.S. class, and we're going to be dabbling into a little world history, but hopefully that houses law in a broader construct so you understand Marbury versus Madison more. And if you were absent, I started class with this big question, philosophical question: what are the origins of law? And some people talked about, natural law, that they happen organically. Some say they're arbitrarily created by whoever is in power. Some people spoke of popular sovereignty. It comes from the people. Some people who are religious feel law comes from their religious background. So it's a little bit of a debate, and when you take government class, if you haven't already, you'll go into great detail on the origins of law and Hobbes' Leviathan and Locke and this sort of thing. But a word that emerged from this is codified. Now, codified means formal and written down. And there's little or no evidence that we needed codified laws in the early part of our story. When we were hunting and gathering and we were agrarian, there didn't seem to be a need to have formal law. But once we became civilized 5,000 years ago, codified legal codes were part of that transition from agrarian man to civilized man. So that's the philosophical side of it. And really quick, I'm going to go through this. The earliest evidence that we have formal law came back in 2350 BC in Babylon. That's a long time ago. And this is the first legal decision we have from 1850 BC. And it's a murder case of all things, and the clay tablet reveals the finding, okay? Now, Hammurabi's code is probably considered the most important legal milestone. These were 282 dictates that Hammurabi ran Babylon by, and it's the actual code. Here's the stone where we have it. So a lot of legal scholars would say Hammurabi's code is ground zero for law. And then the Ten Commandments. Now, I understand this is a public school, and I understand this is a religious thing. But if you take the religion out of this idea of rule of law, and the way I see it simply is a two-part sort of thing. Everybody has to follow the law. But more importantly, people will come and go. Laws stay the same. And if you look at the early part of our story, whoever's running the show, new set of laws. They die, new set of laws. With something like the Ten Commandments, these laws were established forever and ever. People will go, but the laws stay the same. So that's an important legal milestone. Then you look at the Romans, the first republic in history. They had these 12 tables in which they ran their country. And there it is posted. Everybody can see those. Here's what you have to do. Here are here's your rights. Here's the laws you have to follow. That sort of thing. Okay, so this is old. I get this is really old. And then Justinian's code about 1,500 years ago. Now, he created the first civil law. Now, criminal law would be stuff that's punished by incarceration, things like arson and murder and assault and battery, where civil law can be fixed with restitution and money. So, for instance, if you were to run into my car in the parking lot, I don't want to send you away to be incarcerated, but I would like you to fix, the damages on my car. I'd say, hey, you caused $1,000 in damage. Oh, damages. Okay, here's $1,000. Okay, we're cool. We can live to fight another day. So that Justinian's code is the root of civil law. And then the Tang code. Now, the Tang code of China was the ground zero for the Eastern world. Okay, and there was 500 sections and 12 volumes, and these 12 volumes had to do with just about, any facet of law that you would need. Okay. And they had it very organized, and they had some punishments that would probably be not so agreeable in modern times: flogging, caning, imprisonment, exile, and death. Yeah, here's a cartoon of somebody getting caned. I didn't use an actual person, I used a cartoon. So it was rough, but Hammurabi was rough. You can say old legal codes were pretty rough by modern standards, okay? And they had some situations with leniency. So the Tang Code was the foundation of Eastern law. Now, you could say the foundation of Western law is this Magna Carta, and it's considered one of the most important documents in history, certainly to the West. And Winston Churchill had a beautiful quote that sums it up. Here is a law which is above the king and which even he must not break. This reaffirmation of a supreme law and its expression in a general character is the great work of Magna Carta. And this alone justifies the respect in which men have held it. And again, another example of rule of law. Everybody has to follow the law. People come and go, laws stay the same. And then you look at 1689, the English Bill of Rights. This heavily influenced the American Bill of Rights and is the product of Enlightenment thinkers like John Locke, okay? So America was deeply, deeply influenced by this. And then the American Bill of Rights, which I know I beat you over the head with. Okay, that is a wonderful document that has been emulated by country after country because, in my opinion, the American Constitution is a brilliant document. I will say that publicly, and I will argue that point. Which brings me to the crux of today, Marbury versus Madison. This made the Constitution the supreme law of the land and established judicial review. And again, I think it's the most important precedent. And there you can see it carved in the wall. It is empathetically the providence and duty of the judicial department to say what the law is. This has brought order, this has brought structure to this country since 1803 when it was agreed upon. But let me tell you the story of how we got there. Okay, so we have Thomas Jefferson, who was a Republican, and he defeated John Adams, who was a Federalist in the election of 1800. Hopefully you know that already. Now, Federalists have control over the judicial branch, okay? So the Judiciary Act of 1801 increased the number of federal judges. On his last day in office, Adams fills the court with as many of his judges, his Federalist judges, as possible. They were nicknamed the Midnight Judges because Adams waited till 9 o'clock on his last night. So a little shady, a little sneaky. Jefferson was not real happy. Here's a visual. Here's Adams saying, here's my people, and Jefferson saying, hey, I'm in charge now, and my people aren't on the courts, okay? And so Jefferson had a problem with this, okay? You can get that. So Jefferson becomes president the next day, and some of Adams' judges have not even received their forms yet because it was at the night before. So Jefferson says, no, they can't be judges. So we get a debate here. We get an argument here. It's a pretty heated argument, okay? Let me tell you about the Madison and the Marbury versus Madison case. So Jefferson orders James Madison, his Secretary of State, not to give the papers to the judges. Jefferson accuses Adams of packing the court, and Jefferson's pretty upset by this, okay, to reiterate my point, as you can understand. Now, here's the Marbury in the case. Now, William Marbury is one of the judges affected by Jefferson's decision, and Marbury demands the Supreme Court examine the case and force the executive branch to hand out the papers. So Marbury says the Judiciary Act of 1789 gives the Supreme Court the right to do this. That was his evidence and his argument. Reminder of the Judiciary Act of 1789, it created a federal court system with 3 levels and outlined the powers of each. Also required that the Supreme Court to order the paper to be delivered. Okay, which brings us to John Marshall. So John Marshall, he's the Chief Justice, and he's a Federalist, and he listens to Marbury's case. At the end, Marshall agrees that Marbury had been treated badly. He's been treated unfairly, and that the Judiciary Act would allow the Supreme Court to force Madison into making Marbury a judge. Okay? Now here's the big decision. Marshall had to decide whether this was constitutional or unconstitutional. Here's the million-dollar question. And in the end, Marshall decides that forcing the government to make Marbury a judge would be unconstitutional. Okay. So that's the end of the story in a sense. But here's what's important. This is the big point. Judicial review. Marshall's ruling established judicial review, meaning the Supreme Court can declare an act of Congress unconstitutional. So let me put this dollars to donuts for you. A bill gets started in either the Senate or the House, okay? And they have committees and they argue and it goes through the Senate. And then it goes to the House, and the House has their version of it and they tweak it out. 435 House members, they decide upon it. So you have 535 people in the process to make a law. It goes to the president's desk. They sign the law. Now we have the executive branch. And then the Supreme Court can take all of that work and go, nope, done. Doesn't work. Okay? That's incredibly powerful. See my visual? Yeah, the scales of justice tipped. Okay? And here's the judiciary branch. They got really powerful. So what is the outcome of Marbury versus Madison? Judicial review has increased the Supreme Court's legal authority, making it a much stronger branch. So what does that have to do with today? We learn about history to apply it today. So as of making this video, this is July of 2022, this is our Supreme Court's most recent picture. Now, Judge Jackson is not even in here yet because she just got officially put in a couple days ago. So this is the most recent photo I could find. And as of making this video, here's some heavy-duty cases. Now, Roe versus Wade, a couple weeks ago, it switched after almost 50 years that states can decide whether women can have abortions or not. Then we have some cases on the horizon. The Obergefell versus Hodges case. This legalized gay marriage 7 years ago. That very well may go away. Griswold versus Connecticut, the case of contraception, that people have access to contraception. That may go away. Kennedy versus Bremerton schools. That's very recent. A public school teacher led his athletes in prayer, and the Supreme Court said that's fine, you can do that. So as of next year, I could lead students in prayer if I so chose to. And that affects my life and your life. And Loving versus Virginia, which allowed for interracial marriage. That's a long shot, but that might be changed too. So judicial review, these 9 people, well, 8 of them, Judge Jackson will be in the picture really soon. They can decide on, really the direction of this country, okay? So in terms of being absent, if you go to Google Classroom, very traditional class, there are 10 questions, and it's called Class 30 assignment. You can't get more vanilla than that. So if you were absent, hopefully from this video and from your research, you can answer those 10 questions and turn it in. And the big point is Marbury versus Madison. The Supreme Court is the law of the land, okay? The buck ends there, and it created this idea of judicial review, okay? And hopefully those are the 2 big points you can walk away with. So anyway, thank you for watching.